Good morning. Do I have the plaintiff on the line?
Yes, Your Honor.
Do I have the defendant on the line?
Yes, Your Honor.
Now, on the defendant, I have LS Realty Investments. I also have I can't read this writing. I'm sorry. It's GEORG, I think Y, and then MILLA. Do I have those people on the line?
No, just George, Your Honor.
It's George? Okay. Who was the other person?
That's my mom. She's my partner.
Okay. All right, we'll go ahead then and start. Good morning. My name is Renee Jordan. I'm a hearing officer. Today is Tuesday, March 12, 2024. The time is 10:45 a.m. This is McDowell Mountain Justice Court case number CC2024, and this hearing is being recorded. And what is your relationship with Development LLC?
That's my company.
So you're the manager, member, whatever?
Yep.
Okay. Do you have any witnesses with you?
I do.
And who is that?
Dan.
And is he with you? Because I don't see a separate phone number for him.
Yeah, he's here. I'm actually on a job site, unfortunately, right now, and he's on the job site with me.
Okay, because I'm going to need him here when I swear him in. And who else do you have?
Blake.
Blake?
Blake.
Okay. Anybody else?
No. And I have them if they're needed. I'm not sure that they'll be needed, but
well, if you're going to use them as a witness, gather them, because when I swear you in, I need to swear all of you in at the same time.
Is that happening soon, or?
Yes, as soon as I ask the same questions to the defendant. So, yes.
Okay.
All right. Moving over to the defendant. Please state your full name, spell only your last name.
Georgi Gebudayev, Yagudayev.
And your affiliation with LS Realty Investment LLC?
Owner.
Okay. And what is the address of the business?
35713.
And the phone number?
602-335-9774.
And do you have any witnesses with you?
I don't.
Okay. I'm going to swear you in. I need everybody here now. So, okay, I see two people. All right. Raise your right hands, everyone. Do you solemnly swear or affirm the testimony you're about to give this court is the truth, the whole truth, and nothing but the truth? Let me hear from the defendant.
Yes.
Let me hear from the plaintiffs, witnesses.
Yes.
I didn't see the other one. Hear the other one.
Yes.
Okay, thank you very much. Okay, the amount of the claim is $3,500. There is a counterclaim for $1,637.43. So what's going to happen today is we're going to hear from the plaintiff and their witnesses, and he's going to give their testimony. When I'm done with the plaintiff giving the testimony, then I move to the defendant. If the defendant has any questions of the plaintiff, please ask. If there are no questions, then the defendant will go into his testimony. When the defendant is done, we go back to the plaintiff. If the plaintiff has any questions of the defendant, please ask. If there are no questions, then go into your closing comments. We go back to the defendant for closing comments, back to the plaintiff one last time for what's called a rebuttal. Plaintiff files the lawsuit, plaintiff gets the last word. So the defendant gets to speak twice and only twice. The plaintiff gets to speak 3 times and only 3 times. Please do not interrupt one another. I cannot hear multiple people at one time and make sense of what's being said. I may interrupt, and I apologize ahead of time, because sometimes on these dial-ins, a phone, telephonic, it is hard to understand people, so I may ask for clarification. I'll try not to do it, but I just want to warn you ahead of time. I've been known to do it, and I apologize. I may ask a yes or no question. Please only answer yes or no at that time. But if you wish to expound upon it, please do, just not at that time. Today is your day to be heard. I need to hear everything that you need to tell me. Please do not repeat yourself, because if you do, it could take away from other things that you need to tell me. And because we have a time constraint on these hearings, I have another one coming up. I don't want to have to you not tell me something that I need to be told. So please remember, tell me everything that I need to be told. When I make my decision, I will say for the record, so you know it's coming. I will tell you what it is and how I came to it. In small claims, there's no appeal, so you may not like it or agree with it, but it is final and binding. The court will then mail you out a copy of the notice of the decision. Now, I apologize. Excuse me. Excuse me. Okay, so let's go ahead then and start with the plaintiff testimony, please.
Your Honor, I have a quick question before we start with that. Is it appropriate or not during testimony or at any time to object?
No.
There's like a real thing? No.
No, this is more of a informal hearing where you don't have to stand up and be at the podium and so on. But no, there are no objections, or there's not even a lot of legal documents that you can actually file in small claims. So whatever you have to say, the defendant, if they have questions, they can ask questions. Or if you have questions when the defendant speaks, so be it, but you can't object. So go ahead.
Got it. Okay. All right, well, this is a pretty simple case of breach of contract. The defendant is a real estate investor and called me over the Christmas break as pertaining to two properties that he was looking to get flipped, basically. And because he uses hard money loans, has holding costs, and wants to get things done as fast as possible. I agreed to look at both properties, and after doing that, decided that it would be more prudent to work on one property at a time. After finishing the first property, or while finishing the first property, started assessing and negotiating a contract for the second property. The second property was something that I've never seen before. My framer of 25 years has never seen before. It was a very unique circumstance where the structural framing had been severely modified inside of a second-story Scottsdale condo. Upon first seeing it, and I don't know, can I point you towards my evidence while I'm giving my testimony?
Sure.
Okay. If you look at A1, you can see this is the original thing that when you walk in the front door, you see the attic spur down. It's the first thing I saw when I walked in. And you can see that the original beam that's marked on the photo is a structural beam that holds up the roofing system. And it had been cut in half, and then I believe some other work by another contractor that the defendant had brought in, tried to cover this up with drywall, but the roof system had been compromised at that point. So it was the first thing that we decided that we needed to address. And if you look at the plan, the approved plans, B2 and B3 and B4, you can see that the approved plans address this specific issue that's going on for the roof system. So upon seeing that, I knew that there was a lot more issues that were going to come up, and it just seemed like a real headache, a real problem project that I was not actually looking to take on at that moment. But the defendant was insistent that we give him a quote for repairing the structural framing so that we can move on to renovating the whole place. And I just want to also say that this is like I said, a second-story condo, but it's tied into like 3 or 4 other properties. So the danger of something happening or this continuing, the way it was, it had to be fixed immediately, basically. and it was kind of a dangerous situation. So we negotiated the contract. I guess I'll refer you to Defendant's Exhibit 1. The contract is very simple, very plain, states exactly what we're willing to do. Usually for something like this, I will tell a client, we're going to be 5 to 6 weeks out before we can even set aside the 2 to 3 weeks that it might take to do this project from start to end. But he was very adamant that he's losing money every day on holding costs because of the hard money loan. So he wanted me to do it as soon as possible. Waiting 5 to 6 weeks was not an option. So therefore, I wrote up the contract and tried to get dates secured by getting a check for 25%, so I could secure the dates. He was not willing to do that until the plans got approved by the city. So this really tied my hands because I could not necessarily block out 2 to 3 week section of time, and I wasn't sure exactly how much time it would take, but I needed to block out that time so that we could do continuous work. I couldn't do that, so finally the plans got approved. I think it was around the 24th, and he gave me a check, and we agreed on the terms of the contract. He signed it, I signed it. But at that point, the understanding was that since I could not reserve the time, what I did in the contract was I gave him a window of 4 weeks. And I said, within this 4-week window, I will be able to peel off days and come with my crew and get this done as fast as possible. We can work on different, odd days of the week, like Sundays or Fridays or whatever, and come in when there's possible time for my crew to come in. And that's exactly what we did.
Where is that modification? I'm sorry to interrupt. Where is that modification? I see the contract and I see estimated start date January 30, estimated date of completion February 24. Is that what you agreed to, or did you make a modification to this contract?
So that's what we agreed to.
Okay.
That's what I'm saying. The estimated date of completion, so that you have an estimated start date and an estimated start of completion is a win that we were going to get it done. It doesn't say in the contract that we were going to work every single day in between those 2 dates, right? It was just that was how much of a window of time we had to complete. Whether it took us, 10 working days, 20 working days, or all 30.
Okay.
That's what we had.
Okay.
Okay, so that's exactly what happened. And so immediately upon getting the 25% down, my crew went to work. We first had to clean up the contractor's mess, and then we started doing demolition and erecting temporary walls and framing. During this time, the defendant is calling me, complaining about things that just seem to not make any sense. It almost just seems like he's trying to find things to complain about. Things about the other job that was already completed, that he had given me a final check for, that we had signed off on, all the work was done, and he was happy with that job. He's now complaining to me about other things, and I just didn't see the relevance of that. He also wanted us to move faster on the job that we were currently on now, the framing job in Scottsdale, and was complaining to me while we were doing this. He would, I would sometimes have 2-hour phone calls with him where he was complaining to me about how after signing the contract, after agreeing to everything, that we were ripping him off, that we were charging him too much money, and that he could find someone to do it cheaper. And so we were supposed to get another check pretty quickly as we were coming up to being 50% complete on the project. I do believe he understood that and tried to time it to where he could come in, and we had figured out all the problems, we had ordered all the wood, we had started all the processes, and we had gotten to a point where somebody could come in and complete that work, and he came in and said, I can find someone to do it cheaper, basically, so you're done. Unless you can finish it a lot quicker than what you said, you're done. And we were in the middle of hanging this beam as he came in and said that, and I told him, I said, we're not going to stop right now, it's not safe. We took another hour and a half, whatever it took to secure that beam, and then packed up our tools and then left. This was a Sunday when he breached the contract. And by the way, we had permission to be there on that Sunday. Not only is it allowable to work there for the HOA, but I have a text message. You can look at my exhibit. D1, it shows the text from the defendant approving of the times that we were there to work, which he claimed was another reason why he wanted to breach the contract. And immediately following that, I went home and there was some back and forth with the defendant and I at that time, where he had agreed that he owed me money. He wanted to give me like $500, and I was saying to him, I need to go home and do the hours and figure out where we're actually at for the job, for what you actually owe me still. And that's what I did. I left and I filed this lawsuit and, did the math.
Okay.
If you look,
I'm sorry, go ahead.
I was just going to say, if you look at the, I submitted a timeline that has the hours and the money owed as well. If you look at that, you can see what my calculation came up with. I also included loss of opportunity because I did book out time during that window of time where my crew was not booking any other work. And so there was, I believe, like 20% of loss of opportunity to breach the contract.
Okay, well, let's talk about this 3,500. You got the 5,250, but the second 5,250, you were already halfway through?
So I would say we were about 40 to 45%. It's very subjective, right? It's how do you really measure that? But if you include all of the planning and figuring out and ordering of material, and I would say we were about 40 to 45% done. Okay.
Now, this lost opportunity, did you have other jobs that you turned down? Because in order to get money for lost opportunity, you have to prove to me that there were other jobs that you turned down that you couldn't do. And I don't see that.
Yeah, I didn't bring that proof.
Okay, well, let's go through this 5,250 though. If you were halfway through, he still owed you 5,250, but he never paid you the 5,250. But you're saying you were 40 to 45% done, so he owed you roughly 3,500.
Yeah, and I just did the hours, based on my crew that was there, and so that's really how I came to that number.
What do you mean the hours of your crew?
So I went back each day that we worked. Not that we had an agreement for hourly or a daily rate or anything like that. It was a project cost, but just to get a better idea of where we were actually at, because like I said, it's subjective. Whether we're 40 or 45% of the way through. I just went and did the cost of my crew, how much it cost me to pay my crew to be there, and how long we were there, and on what days, and all that kind of stuff. So that's how I came up with that number.
Okay. All right, I'm going to move over to the defendant. Do you have any questions of the plaintiff?
About what he said?
Yes, any questions of him?
I do.
Okay, I'm sorry?
I don't have any questions.
Okay.
I'll just speak my part.
Go into your testimony, please.
Me?
Yes, it's your turn.
Okay. So if you look at, I'll go step by step. If you look at the contract, it states January 30th to February 27th, right? How did we come up? He's saying that it was for the job that he quoted me. If you calculate the days, it's 21 business days from January 30th to February 27th. 21 business days at $1,000 a day comes out to $21,000. If you scroll on the contract, it says deposit upon approval of contract to secure dates above. So the dates above was I had to pay him just to secure the dates in advance because he was pushing me to give him a deposit before the architectural plans got approved. While he was working at the previous job, if you can see, based on his timeline, he worked for 4 days like he stated. He came into work on Tuesday, he came into work on Wednesday, then on a Friday would be February 1st. He was at my other project trying to install a dishwasher. He was there all day by himself. And he waited for the final payment for the electrical box. When his electrician had to finish the work, electrician came on a Saturday. Okay? He came in on a Saturday, fixed whatever he needed to fix, and then I would like to present a YouTube video about the work of fixing the electrical box and then peeing on the house. So if you go to YouTube and you add Ellis Realty Investment, you'll see the video of his worker working on the electrical box and then peeing on it. On that Friday, the day before, when I gave him the final payment, he said that he can't work on Saturday, he can't work on a Monday, he has to come in on a Sunday. I told him it was a high-end HOA that I'd rather for him not to work. What he said is check with the city ordinance, which I did. The city ordinance stated that he's allowed to work from 10 to 3. But I had to put it in writing with the HOA to approve. I told him he can work until we get a complaint. That Sunday, at around noon, I get a complaint where Adam told me that the HOA representative was at the property about a noise complaint. I told him to stop working. He told me we're not gonna follow the city ordinance, even though we had an agreement that he would stop working if I get a complaint. Understand, this is HOA and I buy and sell property. Even if I sell a property, HOA still got to approve the new buyer. My previous experiences with the HOA, sometimes they take 2-3 months before they approve the buyer. I let the development know. He continued working. The ordinance, if you can see Exhibit 3. If you look at the Exhibit 3, this is the manager from the HOA that sent the complaint, saying that the hours are from 10 a.m. to 3 p.m. He came into work at 9 in the morning. When I came in at 3 o'clock, they were standing around talking. When I told them they had to go, his worker, who is a witness, said that he had to finish the work. He had to finish putting up the beam because it was not secure. If you look at the complaint was he led its OSHA regulation. It had structural damage. Part of his school was his son, that is also a witness, and his high school friend. When they started the work, was underage because he turned 18 that Friday. Because Adam said that he had to go. Adam said that he had to go for his birthday party. And if you read the complaint, I didn't fire him. I told them that I can find cheaper work because he quoted me for the electrical for a 1-bedroom condo. Verbal quoted me $12,500. Where previously on the 3-bedroom house, he changed the whole electrical box for $4,800. He did the work on the previous, and I paid him in full, even though it was more than what I thought it would be. Now, if you look at Exhibit 4, if you look through it, this is not 50%. When I came and I asked him, how far are you in? He told me he's in 30%. Now, if 21 days that he worked, right, at $1,000 a day, because it's 21 business days, he never said, he pushed me to reserve the time for the days that you see. He went and pulled the permits. If you can see on the timeline, one second, I'll tell you what exhibit it is. January 26th, he pulled the permits at around 10:09. He sent me a contract. He emailed me a contract at 9:57. The contract was based on the structural work. If you can see, he pulled permits on everything, for building, plumbing, electrical, and material, where it wasn't part of the contract. Because loss was also not part of the contract. If you look at his timeline, where it says January 29th, to receive first wood delivery, I was there with him. Home Depot dropped off the delivery at my garage. And if you look at the last exhibit, where the dishwasher, not the last exhibit, it's exhibit 7. If you scroll down where you see the dishwasher, if you scroll all the way down, you can see on the left, that's the wood that the Home Depot dropped off at the garage, where me and Adam was there for 10 minutes. People that he was there for 4 hours.
Was this dishwasher part of the contract?
It was part of the contract from the previous house.
All right, so it's a separate contract. And I don't have the contract for the prior house. I have the contract for the work that he did that he is suing you for. So where is the contract? So let's go. I have some questions because we're going back and forth between two different contracts. Now, the 150, you are suing him for 1637. What is that made up of?
So if you looked at the 4 days that he said he worked, that comes out to $4,000, right? So that leaves a difference of my deposit of $1,250. Where you see on Exhibit 7, the installation on the dishwasher is $150. If you look at the videos and the exhibits, he was loading the dishwasher, the old dishwasher, into his car. It was part of the invoice that is on the Exhibit 7. So if you look at the video, he loaded, I helped him load the dishwasher in his car that Friday. When I fired him on the Sunday, he took the dishwasher and left it on the public sidewalk. When I asked his son and his friend to move it from the sidewalk, from a public sidewalk, so people can walk through, because I don't want to be responsible for it.
Okay, hold on. This work order here says install dishwasher. Did he install a dishwasher?
He did.
Okay, what are you talking about leaving a dishwasher on the sidewalk?
When he installed the dishwasher, he installed a new dishwasher. He took the old dishwasher. The agreement was for him to install the dishwasher and take the old one out and throw it out.
Okay.
He loaded the old dishwasher, into his truck. Once I let him go, 2 days later, he left the old dishwasher in the Scottsdale place on the sidewalk. When I asked his son and his friend to move it from the sidewalk, his other worker that I never spoke to threatened me and said that he's not taking any orders from me. So if you can see from the exhibit, the dishwasher is in the garage.
Okay, so you're suing him how much for that?
Because he told me it will be $100 to install the dishwasher and $50 to haul it away.
Okay, so you're suing him $50 for that. And then what is this $227.43 plus $110 transfer fee? What is that?
Because he pulled four permits where he only was supposed to pull 1 permit. That cost me more. And since he pulled the permits back, now I have to pay $110 to reinstate the other 3 permits. He
pulled the permits without your permission? Is that what you're saying?
Yes, because if you look at the
well, how could he pull them if I'm confused. How could he pull a permit?
Because he went to the city. If you look at the contract is based on structural work. It wasn't, there's nothing that states about plumbing, there's nothing in the contract about electrical or mechanical. If you want to look at the exhibit here.
But my question is, why do you say he was not allowed to pull these permits? Why was he not allowed to pull them?
Because it was not part of his job.
Okay, but this permit that you provided me was for $303. You are saying it's $227 plus $110. Where did that come from? I don't see those amounts. What?
227. If you take the 4 permits that we got, the 227 was that I paid extra for the 3 permits that he pulled that he wasn't allowed to do.
I don't see that in your evidence. I only see one for 303.
Right, and if you look, it says building, plumbing, electrical, and mechanical, and it was based on the square footage.
Oh, okay. Let me rephrase. I only see one City of Scottsdale building permit for $303.23. You said he pulled 4. Where are those? You did not give me those.
They're on that paper. If you look at the permit, if you scroll a little bit down, the permit, first thing was building, second was plumbing, third electrical, fourth mechanical. Total 85 cents per square foot, which came out to 303.
Okay, but I don't see any other permit is what I'm saying. You said he pulled 4 that he wasn't allowed to. I only see one for 303.23.
Right, because it's 4 permits into one. So he pulled 4 permits.
Okay, so you're saying you're out $303.
Yes. He was only supposed to pull a permit. If you look at the permit, it says building. He was only supposed to pull a permit for the building, not for plumbing, electrical, and mechanical. Okay,
that we'll get into. Okay, so and then what is the $1,250 that you're suing for?
So like I said, he told that he worked 4 days. If he worked 4 days from the time that he started to the time that he got fired. He worked for 4 days at $1,000 a day. That was their quote to me. For 21 business days, it came out to $21,000.
Okay.
He worked for 4 days. That equals to $4,000.
Okay.
The initial deposit was for $5,250. So $5,250 minus the $4,000, that's $1,250.
Okay, I see how you got to that. All right, I'm going to move back to the plaintiff, and I have some questions for you. On the install of the dishwasher, I do not see anywhere on this invoice that you would haul the other one away. Were you responsible to haul it away?
I was not. Do you want me to explain further or just answer the question?
Well, I want you to answer this question, but then I have other ones, and of course you can explain all of this in a moment. All right, so
it was not part of the payment.
Okay, but it was put onto your truck or a worker's truck and then dumped somewhere else. Why was it just dumped there and not dumped at a dump or whatever? Why was it dumped at another job site is actually my question.
That's a good question. So the defendant asked me as a favor if I would take the old one away, and I agreed to. And so I put it in my truck. Usually what I'll do is the next time I go to the dump is when I'll just, include it with whatever else I'm hauling away. The next thing that I was going to be hauling away happened to be at the defendant's second project. So I was going there to work. So I went there and I put the dishwasher with all of the other debris that was going to be going to the dump anyways as part of that job. He when he fired us, he somehow in his mind separated that I had to pick that piece of garbage out of the debris and now haul that off to the dump separately because it was somehow part of a different job.
When you hauled everything off, was the dishwasher there or gone?
So the property comes with a garage that is detached, and so we had done the first thing. If you look at my list of the timeline, the first thing that we did was haul off about 8 tons of debris left by the previous contractor to clear out that garage space, so that when we did our demo, which we did, we were able to fill up that garage again with more debris, and then when it gets full, we were going to come and haul it away, which is where the dishwasher was, in that garage with all the other stuff waiting to be hauled away.
Okay, and all the other stuff that was in the garage waiting to be hauled away, did you haul it away?
No, we got fired before we had a chance.
I see. Okay. Tell me about this permit for the $303.
Yeah, so a lot of the confusion that was going back and forth with the two of you is because the defendant doesn't understand how the permits work. That's what I think, just based on what he's saying. If you look at the plans that I submitted, let me see. So if you look at plaintiff's exhibits B2, B3, B4, mainly B2, you can see on that page that it has everything from demo to electrical to plumbing to framing. It has every aspect of what these plans are approved for. And when you go and pull the permit, you cannot just pull a demo permit. You cannot just pull a structural permit. The permits all come together because the plans are all together. So I did what the city of Scottsdale allowed me to do while I was in the office. Had they allowed me to just pay for and pull a framing permit, I would have done that. But it doesn't work that way.
Okay. All right. Let me see if I have any other questions for you. All right, go into your closing comments then, and if you want to add something to what we just discussed, please do that too.
I had some questions for the defendant.
Oh, yes, go ahead.
Okay. So you testified about a video about a worker doing electrical work at another property, right?
Actually, previous property, right?
What is the relevance to that having to do with the breach of contract for this case?
Okay, I'll go. You with me.
Where'd he go?
I'm here. I'm just telling him why I fired him.
Well, that wasn't his question. His question wants to know, why is that relevant to what this job is?
Because that's why that led me to fire him. Because
Okay.
R4-9-108, it says a contractor shall perform all work in a professional and workmanship manner.
Okay.
That's part of the ROC rules.
Okay, you answered that. Do you have any other questions of him?
Yeah. So you stated that you spoke with the HOA about the appropriate times to work on Sunday. Is that correct?
No. You told me to look up the ordinance. I looked up the ordinance online. It was a city of Scottsdale ordinance.
So you never had a conversation with the HOA about the approved times to work on Sunday?
I never had.
Never. Okay. Okay. So did you get a copy of my exhibit? Did you see the exhibit C1? Did you have that in front of you?
Yeah.
Can you read it?
All you were telling me that Wendell, a guy that I never met, that I never seen.
Your Honor, I just asked him to read it, not explain anything.
I can't read the email.
You can't read it?
No, because I have to look for it.
Is there a reason you want him to read this? I don't want anybody harassed for any reason, okay?
No, I'm not trying to harass. I'm trying to get his memory recollected about the conversation we had about the HOA. and times of working. He doesn't have to read it. It's fine. I'll just state that it says that we were allowed to work. In his words, we were allowed to work from 10 to 5 on Sunday. That is his text message. That's what he said, and that's what I was trying to get him to confirm.
Well, the email that I have shows 10 to 3.
From the HOA manual.
All right, hold on, please. Go ahead. I'm talking to the plaintiff now. What, please?
First of all, he just testified that he did not speak to the HOA about work hours on Sunday at all. The letter that he submitted that you're referring to happened 2 days after the incident, so I don't know how that would be relevant to us knowing when we're allowed to work or not.
Okay.
The only thing that we were going by was the property owner telling us that 10 is time to work, which we did. And then when the HOA representative showed up and said, "Hey, you guys are working here on a Sunday. I'm not sure that that's allowed." He said, "I'm not sure that that's allowed." And I said, "Oh, well, we have the homeowner telling us that it's okay. I thought he checked with the HOA." And he said, "Oh, okay, well, maybe it is allowed. I'm not sure." And that's when you can see in that same Exhibit C1, I texted the defendant and said that Mr. Wendell from the HOA is here, and he said we can keep working. And his response was, "Okay."
Okay. All right, but do not interrupt. Go ahead.
That's all I wanted to point out. That's all I wanted to point out.
All right. Anything else that you have? Any more questions, or go into your closing comments?
Yes. So I have a question for the defendant. So can you point somewhere in the contract where it says either an hourly or a daily rate that we agreed upon?
It's 21 days, 21 business days at $1,000 a day. That's how you came up with $21,000. $1,000 a day.
I would like for you to show me in the contract where it says that. I don't remember that conversation, but if it's in the contract, then I'd be happy to see it. If you can point to it.
Yeah, do you have a calculator?
Okay, it's not in the contract. Go ahead.
Okay.
Go into your closing comments.
Okay. Yeah, no problem. Your Honor, I think this is pretty cut and dry. I think that without contracts being upheld by courts, I think we'd be in a lot of trouble in this world. And, this is a case of an investor who wanted to get work done as cheap as possible and found a way to do it by trying to fire my company after we had done a majority of the work as far as problem solving, material ordering, and even installation. I will say in my final comment, if you look at the plans that are approved by the city and drawn up by the architect, that beam that we installed, which was only 2 or 3 of all the pictures I submitted of our work, that was like 90% of the work that was laid out in the framing part of those approved plans, and we had completed that. So it was a major part. The next one being the kitchen, which we were about 80% done on that one. So to me, it seems pretty obvious that there's money owed. Maybe how much could be in dispute, but I believe that we have definitely met the court maximum of $3,500, and that's all I've got.
Okay. I'm going to move over to the defendant. You wanted to say something, but unfortunately I stopped you because we can't have people interrupting, as I stated. What is it that you wanted to say in response to that?
Even though it says 10 to 3, or even if I texted him 10 to 5, he came into work that day at 9 a.m. Did you not?
So you're saying 1 hour early?
Yes.
And he's saying that the HOA came by and said, no problem. They were concerned about him being later, and they said, oh, okay, we'll look into it.
HOA representative came with the complaint to him at around noon. Either way, if the ordinance say 10 to 5 or 10 to 3, whatever he thinks, he still came at 9 in the morning.
Did you get a complaint from the HOA?
I did. I had 3 complaints from the HOA.
About the working hours?
about working hours, about them making noise, and if you look at the Exhibit 3, that's from the manager of the HOA.
You got 3 complaints from the HOA. Exhibit 3, I'm looking at Exhibit 3. I only see the one talking about work hours or when they can work, but that again was sent 2 days after they had already been fired. Where is something else from the HOA, a complaint that you got? I don't see it.
The complaint was filed by the neighbors. That's why the HOA representative Wendell came and asked about the work.
Okay, we talked about the working hours. What about the noise? The noise on Sunday or the noise during the week?
The noise on Sunday. That's when the HOA representative came the first time.
Okay, so did you get something from the HOA?
Excuse me?
Did you get something, a fine, a fee, something from the HOA charging you for this issue? Okay.
All I got was an email stating that if you can read the exhibit from Exhibit 3 from the HOA manager.
Right, and that is what the plaintiff is saying was sent 2 days after he was fired.
Right.
He didn't.
He was sent based on his work on Sunday that he did.
Right, and he's saying he didn't know that he could only work until 10 to 3. He was never informed of 10 to 3. So how did you inform him that the hours were 10 to 3? Because this email that you got about 10 to 3 was 2 days after he was fired.
Right, about the noise complaint that he did. I didn't want him to work on Sunday. Please understand, I understand what he provided. It's a high-end HOA community. I reserved his time for 30 days, right? Just another thing that I want you to think about. He said that the job would take 4 to 6 weeks. He gave me estimated times for a month, for 4 weeks. He worked for 3 days. How can he complete the project 40 or 50%?
All right, anything else you want to add?
Yeah, I wanna stick to his dates from January 30th to February 27th. That's 28 days. That's 4 weeks of him working. He put on his timeline that he worked for 4 days. How can he give me a contract for 3 days where he worked only 4 days and he's talking about that he completed 50% of the job? This is what I want to understand. It's not like he worked for 2 weeks or 3 weeks and I stick him on the payment. The previous job that he did, I paid him in full with all his ridiculous little invoices in full, and I have the signature that I paid him in full.
All right, well, he's not talking about the first job. You are.
Okay, so this is because he's saying that if it wasn't based on the contract, yeah, this contract stated that he's going to work for 4 weeks. In his opening statement, he said this is a dangerous and complicated job, which would take him 4 to 6 weeks, right? How can he complete 50% of the project just by working 4 days? That's all I want to know. How can it be? What about the other 26 days? What happens? Or the other 24 days? Then what? His payment or his hourly goes down? He only worked for 4 days. He said that I took advantage of him. He started Tuesday. He came to work on Wednesday because I had to drop off the permits to the HOA. He didn't come to work on Thursday. On Friday, he was at my other job site. He didn't come to work on Saturday. He came to work on a Sunday, which really he was at my job site for 3 days. How can for 3 days or 4 days, because he said that his other workers work there on Friday. How come in 4 days they complete 50% of the job that he quoted would take 4 weeks? And what he just said, that would take 4 to 6 weeks. How can it be 50% during that time? Please, I want to understand that.
Okay. Is that all you have to add?
Yeah, that's it.
Okay, moving back to the plaintiff. Last word, sir.
I'll just point out that the defendant is all over the place with his days. He's saying I worked 4 days and then there was 24 days left, but before he said there were 21 working days. The math just doesn't make sense there. I did create a timeline that shows more than 4 days. He keeps going back to that, but I submitted a timeline with everything on it, so it speaks for itself. As far as anything other than this contract and what happened on this job, I think everything else is irrelevant. And, like he stated, we did a good job for him on the other project.
I never stated that.
Okay.
I think I'm good.
All right, gentlemen, I'm going to make my decision for the record. Here are my concerns. One, the contract does not state anything about charging by day. It says, here's the amount to do it, and here's the deposits. The daily issue is a non-starter. It's not even relevant. It's not written in the contract. Therefore, it's not part of the contract. As far as the permit, the plaintiff is saying he had no choice but to get those other things included for minimal expense because that's the city of Scottsdale regulations, not his. It was the city of Scottsdale. As far as the invoice, it doesn't state to discard the dishwasher. Plaintiff agreed to do it. He put the dishwasher with all the other supplies that were to be discarded, and he was fired before he had the opportunity. Plaintiff also states that he did 40 to 45% of the work. The remaining work he did the first 25%. And of the $5,250 that he was owed, he only got to do 40 to 45% of that, which would amount to $4,200. So my judgment is in favor of the plaintiff for $3,500 plus the process server. No, I show it was twice. Was that just logged in twice, or did you have him try to be served twice?
Your Honor, I served George personally, and I served his company as well.
Okay. All right. So that those two charges are $150, and plus your court costs of $53. Let's talk about the counterclaim. One, again, the contract was not per day. There was nothing stated in the contract. And you were bound by the four corners, called the parole rule, by the four corners of that contract. The daily rate was not there. It wasn't even calculated. So it's a non-issue. As far as the permit, I already explained that. The plaintiff had no option but to do that per the city of Scottsdale. And as far as the $50 for the dishwasher disposal, again, it's not even in the contract. But he agreed to dispose it, and he put it with everything else to be disposed of, but the defendant, fired him. So he never had that opportunity. So as far as the counterclaim, I am ruling judgment in favor of the plaintiff for $0. So my decisions for the record is on the claim by the plaintiff, $3,500 plus court costs. On the counterclaim, ruling in favor of the plaintiff for $0. That is the decision of this court, and you will be mailed out a copy of it. I thank you all for appearing today. This hearing is concluded. You are excused, gentlemen. Good day.
Thank you, Your Honor.